Good afternoon, everyone. My name is John Cornwell, and I'm Plunkett Cooney's Director of Marketing and Business Development. I have the pleasure of coordinating today's webinar, which is sponsored by our Governmental Law Practice Group. Today's topic focuses on free speech rights under the First Amendment of the U.S. Constitution, and specifically the limits municipal officials can place on free speech under certain circumstances, like public comment portions of public meetings, during encounters with public safety officers, and at election polling places. We're fortunate to have with us today three members of our Governmental Law Practice Group: Bob Callahan, Alana Buford-Kamerman, and Rochelle Clark. All of them are well-versed in constitutional law issues, so they are the perfect folks to help us today in exploring this topic. Before we get started, I'd like to take a few minutes to just provide you with some background about today's speakers and about our law firm. For those who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have offices in 7 Michigan cities, as well as in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Plunkett Cooney's Governmental Law Practice Group includes approximately 20 attorneys who have expertise in such areas as election law, freedom of speech, Freedom of Information Act, Open Meetings Act, labor and employment law, police liability, zoning, and much more. Today's webinar is specifically designed to benefit municipal officials, public safety personnel, and insurance providers servicing the public sector. So let me introduce you to our speakers. As I previously mentioned, I'm joined today by Bob Callahan, Alana Buford-Kamerman, and Rochelle Clark. Bob is a partner in our firm's Grand Rapids office. He concentrates his practice in the areas of general civil litigation with an emphasis on municipal law, real estate, and labor and employment litigation. He currently serves as outside counsel to Marcellus Area Emergency Services Association, which is the jointly owned municipal entity, and he served as village attorney for the villages of Cassopolis and Marcellus in southwest Michigan. Alana Buford-Kamerman is a member of the firm's East Lansing office. She soon to be our Lansing office, by the way, will be moving soon. She serves as co-leader of Plunkett Cooney's Diversity and Inclusion Committee, and she's a member of our Governmental Law Practice Group. She routinely defends municipalities in litigation involving an array of claims, including zoning disputes, drone liability, personal injury, and allegations of false imprisonment and arrest. Rochelle Clark serves as co-leader of Plunkett Cooney's Governmental Law Practice Group. She works in the firm's Bloomfield Hills office, where she focuses her practice on the defense of municipal liability claims involving alleged police misconduct, employment liability, premises liability, and other claims brought in state and federal courts. Now, just a couple housekeeping notes and we'll get started. For the Q&A portion of our webinar, we're going to use our questions window on your GoToWebinar navigation display. So go ahead and take a minute to try to locate the questions area. And we'll have you type in questions throughout the program, and toward the end, we're going to really try to answer as many as time permits. Finally, I want to mention that today's session is being recorded, and that recording is going to be available on Plunkett Cooney's website on the event page, usually within about 48 hours, sometimes same day. So if you have colleagues that could benefit from this information, we would direct you to share that link with them or send them to that event page. So thanks again for attending. Rochelle, I think you're up first, so I'm going to turn over the program to you.
Thanks, John, and thank you all for joining us today. As John mentioned, today we're going to be talking about the First Amendment, and on the slide there you can see what the First Amendment says. Generally, the First Amendment basically creates 5 specific rights: the right to the free exercise of religion, freedom of speech, freedom to assemble, freedom of the press, and freedom to petition the government. For the purposes of today's webinar, we're going to focus on free speech rights. Now, in the context of free speech rights, government property can be characterized into one of 3 forums: a traditional public forum, a designated public forum, and which is sometimes referred to, depending on the circuit, as a limited public forum and a non-public forum. And the government's rights to restrict speech, and conversely the citizens' rights to engage in certain expressive activities, is very much related to the type of forum that the speech is occurring in. So what is a traditional public forum? Well, It's been defined as a type of property that by tradition has been devoted to assembly and debate. So it would include places like streets, parks, sidewalks, and other public places that have been primarily used for assembly, communicating thoughts, and just general public discourse. So the rights of government, it's very limited in a public forum in terms of what type of speech they can regulate and preclude. So content-based regulations are only permitted to the extent that it's necessary to serve a compelling state interest. And reasonable time and manner restrictions are okay as long as the restriction is narrowly tailored to serve a significant government interest and also leave open ample alternative channels for communication of information. So basically, restrictions can't delegate overly broad discretion to a governmental official, and it can't be based on the content of the speaker's message. When we're thinking about whether or not a time, place, or manner restriction is reasonable, generally we're looking at the nature of the place and the pattern of its normal activities, and that will kind of dictate what's reasonable in that regard. So in terms of content neutrality, it's pretty much what it sounds like. Restrictions can't be based on the content or the subject matter of the speaker's speech. And so when we're thinking about whether or not a particular regulation is content neutral, we want to ask ourselves whether or not the regulation is in place to limit a particular speaker from expressing their views on a particular issue, or whether it is solely trying to limit a time, place, and manner restriction, or in essence, content neutral. And it's important to note that a regulation of speech or expression that's based on the substance of the message being communicated rather than the manner or the method of communication, it's going to be, it has to be the least restrictive means of achieving a compelling state interest. And so when we think about what the rights of speakers are in a traditional public forum, it's essentially very expansive, and speakers have the most protection in this forum, and their speech can be robust, offensive, and even obnoxious. And so understanding the fact that sometimes it can be hard to think about these things in the abstract, I thought it would be a good idea to just kind of go through a case to kind of put things in context and also show how these ideas come to work in real life situations. So in the Adder versus Armstrong case, the plaintiff in that case, Adder, was a member of the Ku Klux Klan, and he wanted to distribute some political literature on the streets of a Kentucky county. And the police chief denied his request, and he subsequently sued, and he alleged that the statute was unconstitutional. So what did the Kentucky statute say? Well, basically it prohibited people from standing in roadways and included medians as well. But the statute did carve out an exception that allowed, for the purposes of soliciting contributions, individuals to do that, provided that they were at a traffic control device or a warning signal, or an emergency vehicle or public safety vehicle was present with its lights on. And so the primary issue before the court in that case was, number one, whether the statute imposed a reasonable time, place, and manner restriction that was content neutral. And number two, whether the statute was narrowly tailored to serve a significant government interest. The first thing the court did was determine what type of forum we were dealing with. And this was a relatively brief discussion in the case because the court basically said that roadways have long been held in the public trust, and so it obviously was a traditional public forum. And so the next step in the court's analysis was to look directly at the statute. And in looking at the statute, the court decided that the statute was content neutral on its face because it allowed all parties to solicit contributions in the roadways. And conversely, all parties were permitted, or pardon me, conversely, all parties are prohibited from distributing literature. So there wasn't any distinction between what the content of the literature was. It was applied even-handedly to everyone. And so the court used a simple analogy to kind of explain how it arrived at its conclusion. And it explained that under the statute, two organizations with completely different viewpoints, for example, the Ku Klux Klan and the NAACP, would both be barred from distributing their literature underneath the statute. And so therefore the content wasn't necessarily applicable at all. And conversely, under the statute, both organizations would be able to solicit contributions provided they complied with the safety requirements under the exception of the statute. The next issue that the court kind of addressed was whether or not the statute was narrowly tailored. And the court looked to the statute and determined that as interpreted and as applied, it didn't give officials arbitrary discretion to determine who was permitted access to the roadways. It applied even-handedly. And so they turned to the issue of whether or not there was a compelling state interest. And the court determined that the government did have a legitimate interest in maintaining a safe and orderly flow of traffic on its roadways. And so therefore the statute was not intended to limit speech or the content of speech, but instead it was aimed at the non-communicative impact of the conduct. So again, the emphasis was on the fact that the state does have a legitimate interest in ensuring that its roadways are safe. And so the statute served that purpose and was not overly broad, but narrowly tailored to serve that interest. So the key points that we can take away from Adder are, number one, the government's ability to restrict free speech in public forums is severely limited. Public forums are areas where any type of intolerance for exhibitions of speech, petition, and assembly are really at a minimum, and the government has the burden in justifying its regulations that it places on speech. But that is not to say that the government cannot place reasonable time, place, and manner restrictions. And of course, for purposes of determining whether restrictions are narrowly tailored to serve a legitimate government interest, it's only necessary that the restriction be content neutral. And so those are some key takeaway points from Adder. And I'm going to turn it over to Bob, who's going to tell us a little bit about speakers' rights and the government's rights in designated public forum.
Good afternoon. Designated public forum is different from the general public forum in that this is an area, a piece of public property that the governmental entity has designated as a place to be used as a public forum or a meeting, so to speak. The classic examples that most of us are very familiar with would be an area for school board meetings or area for city or village council meetings. And the government does have rights to regulate speech to a certain extent in those designated public forums. And it can restrict speech as long as those restrictions do not discriminate on the basis of the viewpoints being expressed. So once again, we're talking about content, and that those restrictions are reasonable in light of the purpose being served by that forum. Once again, we hear those buzzwords. The restrictions have to be reasonable as to the time, place, and manner. An example of this are in city council meetings back in the good old days. You can see by my picture I've been around for a while. Back in the good old days, I would be at some city council meetings with certain municipalities, and when it got to the public comment portion of the meeting, some citizens who were upset or very concerned about something would go on and on and on without time limitation. Most, if not all, of the municipalities that I have represented in some capacity in the last number of years have placed time limitations on the ability of speakers to present their points. And as far as limitations on content, those prohibitions must be nearly drawn to affect a compelling state interest. Once again, a similar type of standard as we saw with the general forum. An example of the restrictions placed on individuals in a designated public forum and whether they are constitutional or not are seen in a case from the Western District of Michigan, and it was the case of Galt versus City of Battle Creek, and the citation is in the materials you have. And this was a case that was decided by Judge Quist, who is senior status now in the federal court, and it came to Judge Quist on a motion for preliminary injunction that had been filed by the plaintiffs. Now, the plaintiffs were a member of a community organization called FAME, F-A-M-E, and it was an organization that was concerned with police misconduct. For one reason or another, they did not like the City of Battle Creek's police chief. The City of Battle Creek's commission had regulations and rules for public comments during meetings. One provided that public comments would be limited to 5 minutes per individual. That's not a problem, and it's very common that limitations of 3 to 5 minutes are imposed. The City of Battle Creek also had the rule that citizens making comments at their meetings would have to be brief and concise in making their remarks, and they could be ruled out of order by the commission if the citizen, quote, became repetitive or, in the opinion of the chair, takes an inordinate amount of time in making comments. Now, the issue arose when the plaintiffs were at a meeting and they were expressing concern about the continued employment of the chief of police. They asserted he was unfit to serve. One of their complaints they had with him was that he had been involved in the cloning of the pager of one of the police officers for his own personal reasons, which they contended were inappropriate. They alleged that there was personal animosity between this chief of police and the police officer whose pager he cloned. They alleged that the chief of police had had an affair with the police officer at issue. So you have some of the fun personal problems that come up in any organization, but they certainly seem magnified when they're involved in a police department. Now, at one meeting, it was April 6th of 1999, before they could start presenting to the public their concern that this chief of police was having the affair with the police officer's wife, the chair of the city commission ordered them to stop their comments on the threat of having to yield to the next speaker or being ruled out of order and subject to arrest. And that stopped the plaintiffs at that time. The next meeting was on April 20th, and the chief of police had requested to go into closed session in order to hear the plaintiff's complaints against him. And the plaintiffs had the opportunity to do so, but they did not. When it got time to the public comments, the plaintiffs once again raised the issue regarding the chief of police, his affair with the other police officer's wife, and the cloning, and they were threatened with being ruled out of order. One of the plaintiffs was removed from the commission by police officers at the direction of the chair, and another plaintiff was removed only after she continued to disrupt the meeting. So they filed suit, and they claimed that their constitutional rights were being violated, and they sought the preliminary injunction. In his opinion, Judge Quist recognized that this was a limited public forum, the commission meeting, and he noted that regulations by the city of Battle Creek would be permissible as long as they were narrowly drawn to affect a compelling state interest. And the city of Battle Creek argued that it had such a compelling state interest. The court, through Judge Quist, concluded that the issue of the chief of police affair with another officer's wife was not solely a matter of private concern. He ruled that those allegations could directly relate to the morale, leadership, and teamwork of the Battle Creek Police Department, its officers, and accordingly to the public at large. Judge Quist made further note that that type of behavior and that concern was even greater when it involved what he characterized as a paramilitary organization like a police department. In similar fashion, Judge Quist concluded that the chief of police had illegally cloned the police officer's pager was a matter of public concern. The issue of the argument that the plaintiffs had the opportunity to address their concerns in a closed session That was rejected by Judge Quist. The court held that that would be an undue restriction based upon content because it limited the plaintiff's ability to address the issue to the public at large. And so that issue was ruled against the city of Battle Creek as well, and the preliminary injunction was granted. Key points from this Galt lawsuit are, first of all, a moderator, like the chair of committee, council president, is permitted to stop an individual from speaking if that individual's speech itself disrupts or otherwise impedes the orderly conduct of a council meeting. Quite often, those are not based on the words the speaker is using alone, but it would be the actions of the speaker, the tone and tenor of the speaker, things of that nature. And in order to maintain an orderly conduct at a meeting, a citizen can be stopped from speaking if it is irrelevant, repetitious, disruptive, disturbs, or impedes the orderly conduct. Now, my experience is that although city council members, village council members are very, very good public servants, they have their heart set in the right direction. They all too often can be very thin-skinned, and there are always there always is at least one individual in every community that wants to go in and disrupt, challenge public meetings, and they present issues to the council and by setting the time limitation, a reasonable time limit, and consistently applying it. In other words, don't give some speakers more than 3 minutes or more than 5 minutes, and apply that real stringently on individuals who you don't like, or whose opinions you don't want to have expressed. It's sort of like parenting. Sometimes you've got to be consistent in the application. So let's talk about a hypothetical situation, which is not that hypothetical because we've seen a case like this before. It's like the farmer's insurance. We've seen that, done that. The facts in this situation is you have a resident who, like in any community, you have at least one of them, and this resident would frequently attend council meetings and always complain about a prior arrest, alleged crimes that had been perpetrated against him, and the city's refusal to prosecute that. And during a specific meeting, he was ruled out of order by the mayor after that individual referred to a police officer as a criminal. And then after the mayor ruled that individual out of order, the resident then doubles down and he calls the mayor a liar and a coward. Once again, the resident is ruled out of order, and once he's ruled out of order, he begins to curse and yell. Eventually, after the third ruling, the resident is escorted out by the police. Criminal charges are sought against him and filed, and the mayor is the complainant, and he's being charged for disturbing the public meeting. And it's not until a few hours before the next council meeting and hours after he has shared with council members that he has audio recordings of officers saying inappropriate things that he intends to share at the upcoming council meeting, that he is arrested. At what point was it appropriate for the mayor to rule the resident out of order and escort that individual out of the meeting? Any thoughts from my colleagues?
Well, yeah, it's a very tricky question because it's not appropriate to rule the resident out of order just because he stated that he called the mayor a liar or a coward. Those are not appropriate reasons to rule the resident out of order. Now, when the resident starts to curse and becomes disorderly, then I think at that point, it's certainly within the discretion of the mayor to then rule him out of order. And if there are rules of decorum in place that establish that, number one, the council can set these rules to make sure that there's an orderly meeting and certain behavior is going to be prohibited, then I think it would be appropriate at that time to then ask the resident to, stop what he's doing. And if he continues to be disorderly by cursing and things of that nature, escort him outside.
How about when he referred to the police officer as a criminal?
Hello, or good afternoon, everyone. This is Alana, just so you can register the voice. That, at the end of the day, is his opinion, and he's allowed to state that in the meeting. I mean, if we're looking at Galt, and specifically, I mean, as a case example, that's a very similar statement as to what they were stating, and not only that, going a little bit further into the facts of Galt, what was interesting is the affair that they wanted to talk about too had actually occurred 10 years prior, but it was still relevant.
Yeah.
Because it was the chief of police whom they were talking about having an extramarital affair, and then on top of that, cloning the officer's pager with whose wife he had an affair with. All right. So, going to this factual scenario, you have to be very cognizant too of who are we talking about here? Is this just a private secretary who's just taking phone calls at the receptionist, or is this someone who's a public official that we have to instill trust in and watch their morals and values in the sense of what their expectations are in their role? Because with police chiefs in particular, you have things like Brady, concerns of, do you turn over the evidence? Are you truthful? Is your credibility or character ever going to be questioned in a criminal setting or civil setting even? So he has the right to say that. And at the end of the day, you can't take him out at that point.
I think that there could be more of a justification to rule this individual out of order when he calls a police officer a criminal. That gets closer to being a statement that would be libel or slander, referring to, in that opinion, but when you call the mayor a liar and a coward, that's more of an opinion, and I think it has a lot more of a protection. And taking the plaintiff out of the meeting when the plaintiff was yelling and screaming and causing a disturbance. I think at that point that you don't. That is maintaining the order of the meeting itself. What about arresting him about 4 hours before the next council meeting?
Well, yeah, that's going to be an issue, right? Because it's a little too far. That's going to be a big problem because on its face, it's going to look as much as you know, the mayor or complainant will assert that it's not. It's going to look like it's an attempt to either, number one, retaliate against him for exercising his right at the prior meeting, or number two, prevent him from speaking at the next meeting. And the facts in the hypotheticals are particularly important because, you know, he expresses that he has this, you know, quote unquote, damaging information about police officers that he's going to share with everyone at the council meeting. And lo and behold, he's arrested right before the council meeting. That would be very difficult to overcome if a lawsuit is filed. And so it would not be a good idea to seek an arrest warrant in the context of these facts.
And you've expressed, you know, and identified one huge pitfall associated with mayor going and getting an arrest warrant under that. It could be claimed to be retaliation and to be used to chill his speech.
Yeah.
Okay. So, lessons to be taken out of this. A city council or a designated public forum can generally set a time limit for a speaker, provided the amount of time is not related to the subject of discussion. Once again, time limits are very, very common in a council or commission conducting business. You just can't impose that arbitrarily or selectively. Council can set the agenda for its meeting. That is part of an orderly handling of a meeting. And a council can have rules of decorum that address profanity and provide for an orderly meeting free of disruptions. Once again, that has to be applied in a content neutral way. So it's important to remember the context of the speech that's involved at these meetings. A city council cannot exclude a person from speaking simply because it does not like the topic or the viewpoint being expressed. And absent libel or profane attacks, the speaker, as a general matter, is permitted to speak, even if those statements are critical of council members. And as attorneys, we have to remind the council members, the village president or village council president about these things and tell them that we appreciate the public service that they're providing, but they cannot be thin-skinned with these kinds of individuals they invariably will be dealing with. Now we're going to talk a little bit about non-public forums.
All right. Hello again, everyone. So going into non-public forum, this is the type of area that's traditionally very distinct from the open public. So when you're thinking in a general city hall, you have your reception and what have you, but those offices in the back where people do their everyday work, those aren't non-public forums. Or schools where it's traditionally just reserved for students and teachers and what have you. Traditionally, the non-public forum is the place where the government has the most amount of control over speech, because municipalities can enforce, of course, the reasonable time, place, and manner regulations, and of course, again, being content neutral regulations, just so long as they're reasonable in light of the purpose served by the forum. So moving into this specific standard that's applied to this, again, it's just reasonable. So when you're comparing it to the traditional public forums that Rochelle previously talked about, or the limited public forums that Bob talked about, this level of scrutiny is less than both of those. And the case we have, in order to help demonstrate this contrast, is United Food and Commercial Workers Local 1099 versus the City of Sydney. Now, this is a case coming out of Ohio. The plaintiffs here filed a suit based on the fact that they were told to stop petitioning or trying to get signatures outside of a polling area. Now, here in particular, the Ohio statute required that polling places have essentially little flags, little areas placed 100 feet away from a polling station in order to kind of section off that 100 feet square or squared off area before a voter enters a polling area, with the purpose of making sure that voters could go vote free of any undue influence so that they can focus their minds and execute their right to vote. Overall, the court found that this statute was, content neutral. It had a public purpose to make sure that voters could execute their right to vote to the best of their abilities. But what about that area beyond that 100 feet? And that's where we get into the issues of this case regarding free speech. So the first area was the 100 feet outside of a school in particular, which the court determined, well, let me back up a little bit. First, we have the 100 feet outside of the private areas, the YMCA and the church. And so at that point, the court compared these two areas. First, the 100 feet outside of the private areas, the YMCA, the church, and in comparison to the school, which is typically a public building. The court found that excuse me, I'm getting a tickle in my throat. And now I promise I don't have the coronavirus. Pardon. Okay, it has passed. So going back and forth. So going first to the schools, which is typically a limited public forum, and whether or not the 100 feet beyond that could be regulated. Sorry about that. I had to get that cough out of my throat, everyone. Thank you for your patience. So going into the first area, the public sidewalk outside of the polling place. This is the traditional area of a public forum, the sidewalks, the streets, things that Rochelle had mentioned before. The court found here that this was a traditional public forum, one. Then two, that the traditional public forum standard of more stricter scrutiny, that there had to be a compelling government interest to restrict the speech that was content neutral applied. Then the court took that and compared it to the more limited public forums, the school and the private property leading up to polling places. The court in particular there looked at a case called Burnson versus Freeman, which is a United States Supreme Court case. And that's the first off, the case that it used to justify the campaign-free zones. And from there, went into its scrutiny analysis and found that parking lots, walkways, they have, of course, open access, free speech, the higher level of scrutiny. But from there, when looking at that in contrast to the schools and the private property, the court held that there was no evidence in the record at that point, because it was just a motion on the pleading, that by having a polling place located at a school or private property, that the government intended to create a public forum. There was no evidence or allegations indicating that the government had opened those areas for free speech and discourse, right? They were still just a school and they were still private property. Additionally, looking at the facts of that case, you'll see that in regards to the school, the principal and the school officials looked to the police officers and said, hey, we have a safety concern and we would like these petitioners to be removed from the premises. And that there was the government reason, of the public interest reason, to ensure the safety of the students, as well as to make sure that they could still study and work at class. Secondly, in comparing it to the YMCA, the private property, there the landowners had requested that the petitioners be removed. And so the officers who had removed the petitioners at that point, the plaintiffs in this case, were following the guide of the private property owners, people who were working, the private property owners. So there was never a public forum to begin there to begin with, because it was private property. The fact that a polling place had been instituted on that property did not in and of itself, without any additional facts, create any type of public forum. And so it remained a non-public forum, and the government interest provided there was following whether or not, or protecting the interest of the private property owner. And there it was reasonably related. So in absence of any intent of the government to open these non-traditional forums for public discourse and speak, such like as a city, in comparison to a city council meeting, the presence of a polling place in and of itself did not create a public forum. Now, in contrast, again, to the sidewalk outside of the polling place, the court took a much more wishy-washy position, essentially. And in that instance, the allegations in that matter were still unclear. In particular, the complaint in this case did not indicate whether or not the sheriffs or the police officers in this instance, once the people had been removed outside that 100 feet, were they still soliciting them or approaching them and threatening them with arrest on the content of their speech, or from any other, was there any other potential government interest at play? And so in this instance, the Sixth Circuit determined to remain the case back to the district court in development of further facts to see if the government's intent, the officer's intent at that time, was to chill the speech of the speakers. And so with that, I will open the floor back up to talk about, too, what type of speech is protected in the first place and what's not.
Thanks, Alana. I know we're running a little short on time, so I'm going to try to just short circuit this a little bit. We've talked a lot about free speech rights that are afforded to citizens, as well as the government's ability to restrict speech. But it's important to note that the right of free speech is not an absolute right, and there are certain classes of speech that aren't protected or are given lesser protection. I won't go through all of that today, but we'll focus on fighting words. That's defined as words that tend to incite an immediate breach of peace by simply saying them. Personally abusive epithets are generally likely to provoke violent reactions. And sometimes we see racial slurs, curse words falling within the scope of fighting words, but it's extremely important to remember that the context is important when evaluating these scenarios, because in one circumstance, a particular phrase may be considered a fighting word, while in another circumstance, it could be potentially considered not. So it's always important to take into consideration the context. All right, so we're going to open up the floor to some questions.
Okay, let me jump back in here now. Just as a reminder, take a look for your questions window on your GoToWebinar platform. You can type them in right now. That would be something that you could have done throughout the session. And we have one question here. It does, actually it mentions the coronavirus, so I'll start with that. With corona being so prevalent, what can municipalities do if a group asserts First Amendment rights to try to preempt a government ruling that they can't assemble?
Well, I think, one, we have to kind of do the same type of analysis that the courts do. First, let's figure out what type of form are we working with here. And then two, figure out what type of interest are we looking to protect. So with the coronavirus, you're thinking of things such as the health and safety of your citizens. And then three, always make sure as well that this type of restriction is being applied across the board, regardless of the viewpoint, and that it's content neutral when being put in place.
Okay, we have another question here. It has to do with being involved with a police incident. So the question is, what issue do you see if the police are presented with a public disturbance like the Freddie Gray incident in Baltimore? Anybody want to jump on that one?
Well, during the Freddie Gray incident, as you can recall, it was in Baltimore, and after the incident happened, there were numerous days of rioting and public disturbance, and police officers definitely have to be very thick-skinned during those types of scenarios. If the problem is what kind of speech that could inflame or further inflame a situation like that. And one type of word that could immediately have done that in that scenario would have been use of the N-word during situations like that. Under the Chaplinsky fighting words, it could be argued that use of the N-word, especially in a very emotionally inflamed scenario, could cause an immediate breach of the peace just by their mere recitation, or it could be considered a personally abusive epithet, which would be inherently likely to provoke a violent reaction. Under those kind of circumstances, using words like that, especially if they were used in such a manner that yelling and threatening could be something that could not be protected under the Constitution.
And Bob, just to kind of jump in on that, I know that personally I've seen an uptick in cases where the plaintiff, engages in some type of profanity toward an officer, whether it be, the finger or a curse word, and then the officer arrests the individual. And one thing that's important to keep in mind is that as a law enforcement officer, if you're seeing that, you have to evaluate the speech and really think about whether or not an objective listener in that situation would be caused to, would it incite violence? You can't, like Bob is mentioned a few times through this webinar, you have to have thick skin. And so in arresting for fighting words, you have to assess not only what the speech is, but also what the likely reaction to the speech would be.
Yeah. And the abuse of words used towards police officers is really what the Sandul versus Larian case that we were going to discuss is about. Mm-hmm. Police officer having someone told to F off, and the police officer then follows him and arrests him. The police officers have to be very thin-skinned, and it can be argued that the amount of expressions that even could be considered fighting words nowadays is more limited than it was back in 1942. Sixth Circuit in a case, Green versus Barber, 310 F3rd 889, made the notation that standards of decorum have changed dramatically since 1942. Moreover, an indelicacy no longer places speech beyond the protection of the First Amendment. And Green versus Barber dealt with someone suing because of words used towards a police officer and being arrested for that. Unfortunately, in today's day and age, police officers have to deal with a lot more negativity drawn towards them, a lot more lack of respect, and they have to be even thicker-skinned and tolerant of things that are said in their presence.
Great. We've got two more questions here. One of them actually talks about decorum at a meeting, and I think we kind of covered this, but it's probably a good reminder. And the question is, when a person speaks at a public comment or makes public comments at a meeting to a councilman or a mayor, for example, and they're derogatory about the person's ethnic background or sexual preference, for example, can their comments be restricted and they asked to redirect their comments, or if they don't, can they be removed from the meeting?
I think the facts or some of the holdings in Galt really kind of speak to this. There are certain types of restrictions regarding the length of time, as well as is it relevant to the public forum and what's to be discussed. And so you can make some type of calls, but it can't be specifically content biased, right? So making personal statements about a city official doesn't actually go to, you know, your opinion of them, the liar or the crazy person that we had in the hypothetical. You know, that's opinion based, but if you're going into more discriminatory type of conduct or communication, well, then you're not talking about public issues, and if it's not relevant to the forum at that time and what that forum's designated to, then calling that person or cutting them off may be reasonable under the applicable standard.
Great. Thank you a lot. Go ahead, Bob.
And you have the context in which the names were used too.
Yeah.
Mm-hmm.
You know, some thought has to go into it, and it's better to give a little bit of calm, measured response as opposed to just jumping to hold someone out of order. But then again, you have to do things to maintain order and decorum of the meeting. So there's a balance.
And being consistent with it too across the board, I think, is important, because then you run the risk of, you know, no longer being content neutral, because the courts do evaluate that as well in the facts if they're presented. You know, who are you applying this more and more and more to certain viewpoints or not? And then you get the appearance of this isn't in fact a content neutral regulation. This is, on its face it may be, but in practice it's not, and that can get you in trouble as well.
Great. Okay, we're almost up to end of our time here. I've got one last question. It actually talks about panhandling, which is, as I know, a very controversial topic. So the question is panhandling constitutionally protected? And if so, what can municipalities do to regulate it? Anybody want to tackle that one?
The Sixth Circuit. Go ahead.
Go ahead. Oh, go ahead, Bob. I was going to say, first off, have to figure out what form we're in and where we're at. So in that case Rochelle talked about, the first one, you know, this gentleman was handing out flyers and stuff, but there was a restriction on where he could do it for safety reasons, right? At intersections with crosswalks and lights and things like that. So of course you can put in those types of restrictions, the ones that are reasonable in terms of time, place, and manner that affect people's safety. And then looking at non-public forums as well, you know, if it's not open to the public, like the offices or the schools, well, obviously you can put a restriction there because it affects what the purpose of that public place is, right? Is it students or is it people just trying to do their job every day? So I do think there are restrictions. They just have to be properly tailored to the forum in particular that you're looking to protect.
And the Sixth Circuit has held that Panhandling speech that is protected, and that case was Speet versus Schuette, our former Attorney General, and it was a 2013 case. So as much as we might not like it, and as much as the people soliciting for money when we're exiting a highway might make us uncomfortable, that is protected speech, and it can be regulated, but the regulations have to be reasonable as to time and place and manner.
Great, thank you very much. Okay, I don't actually see any other questions. We're up against our time, so just let me wrap up for the group here today. Once we log off here today, one of the things that will happen is you'll have a pop-up survey on your desktop. If you could just take a moment, I think it takes like a minute to complete. Please give us your feedback, especially on the topics for future presentations. We really do take a look at that feedback, and it helps us with our future programming. The other thing I wanted to reinforce with you is that, again, this session is being recorded. We're going to have that recording on our website, hopefully later today, but if not, hopefully tomorrow. So simply visit that event page or steer any colleagues towards it if they need to get this kind of content. It'll be there for them, including the slide deck from today's presentation. So really for me, that and all of our presenters today, that does it for today. We want to thank you very much for being a part of our program. Yeah. And we wish you the best for the rest of the day. Have a great one.
Thank you.
Bye.
Thanks.